Friends, session number 23 of the series on military law relates to the types of court-martial, their jurisdiction and powers. And it also would dwell on certain essential procedures as contained in the Army rules. Court-martials are linked with the process of law enforcement. Uh, the need for maintaining a high standard of discipline, which should contribute to the combat competency, requires that whatever infraction or violation of offenses come to notice, they should be quickly and properly uh, di- disposed of when the matters relate to armed forces personnel, and for that process courts martial they present an effective mode to carry out this mode, process or necessity of law enforcement. There are various types of courts martial, and which one is to be invoked in a given case depends on the nature and gravity of the offense and also the rank of the accused. The four types of courts martial, starting from the one with the greater authority, are general court martial, district court martial, summary general court martial, and summary court martial. We would see in greater detail how they are to be composed, convened, but it should be remembered that a court martial within the meaning of CRPC is a criminal court. The Army Act provisions, they contain requisite authority and provisions with regard to the general court martial, summary general court martial, district court martial, and summary court martial. Just to illustrate, with regard to general court martial, I will read out the provisions of Army Act section 109, which says a general court martial may be convened by the central government or the chief of the army staff or by any officer empowered in this behalf by the warrant of the chief of army staff. So in this fashion, the authority to convene has been indicated in the statutory provisions, that is Army Act. Similarly, about the composition, I would move with regard to GCM section 113, which says that a general court martial shall consist of not less than 5 officers, each of whom has held a commission for not less than 3 years, and of whom not less than 4 are of a rank not below that of a captain. That should indicate that what would be the number of members, what will be their rank, what would be their service or experience or seniority has all been indicated in the Act. Just to indicate, say for example, in this case of summary court martial, section 116 states that a summary court martial may be held by the commanding officer of any corps, department or detachment of the regular army, and he shall alone constitute the court. The third aspect is relating to powers. Now let us see in the case of a DCM section 119, which says a district court martial shall have power to try any person subject to this act other than an officer or a junior commissioned officer. So that should make it very clear that some district court martial cannot try an officer or a junior commission officer for any offence made punishable therein, and to pass any sentence authorized by this act other than a sentence of death, life imprisonment or imprisonment for a term exceeding 2 years. So what DCM cannot award is a punishment exceeding 2 years, life imprisonment or death. So that is how the convening, composition and powers have been indicated under the Army Act provisions, which are listed on this slide. I just read out General Court-martial or summary general court-martial shall have power to try any person subject to this act for any offence punishable therein and to pass any sentence authorized thereby. The only restriction which has been placed in the case of summary general court-martial is that it cannot award a death penalty without the concurrence of all the members. Now, to ensure legality and to get over any complicated cases, there is a regulatory para 459 in the regulations for Army, which states that in all cases for trial by general court-martial, wherever there is a trial by general court-martial and cases relating to either indecency, fraud, or theft, and civil offences except simple assault, charge sheet and summary of evidence, and all exhibits are to be referred by the convening officer to the Deputy Judge Advocate General of the Command or Assistant JAG of the Corps before trial is ordered. And in this manner, suitable and correct legal advice is obtained by the convening authority for all cases where trial by general court-martial is required, or if it is intended that the trial should take place by district court-martial. And whatever is the leeway remaining is covered by the second para, that convening officer should also refer for advice any other cases of doubt or difficulty. So wherever he harbors a doubt or difficulty, he may send that case seeking advice of the Judge Advocate General, and we are reading this in RA para 459. There are certain factors that would decide whether a matter that can be tried by DCM, district court martial, should it be sent for GCM. Now the factors are nature of the offence, whether the offence is serious, it is heinous crime, or it's a simple offence. Prevalence of a particular offence. The offence may be relatively mild, but it is taking place in large number, therefore situation may demand that strict and stern measures are necessary. The general state of discipline. If the discipline is of a high order and there is one aberration, then it doesn't require for a serious view to be taken of the matter. Previous character of the accused. If the accused has behaved in a soldierly manner and unblemished career, then perhaps a more serious view is not needed. And maximum punishment imposable having regard to any existing sentence is also a factor that would govern whether to choose between GCM and DCM. Section 117 enumerates the contingencies under which a court-martial should be or shall be dissolved. That means will be done away with. First contingency is if a court-martial is reduced below the legal minimum. We just saw that GCM require 5 members. Now, if 5 have come down to 4 or 3, say because of illness or somebody is retired, unfortunate death, then court-martial is to be dissolved. If the illness of the judge, advocate, or accused before the finding stage renders it impossible to continue. If they have fallen sick or one of them has fallen sick and it's not known how much time would he take to recover, then also it would be dissolved. Next, if military exigencies or the necessities of discipline, 2 situations, either military exigencies or necessities of discipline render it impossible or inexpedient to continue. And in all such situations where a court-martial is resolved, accused may be tried again when those intervening situations have disappeared or have mitigated. Section 121 prohibits second trial. This is based on the notion of double jeopardy. It states where any accused has been acquitted or convicted by a court-martial or by a criminal court or dealt with under any of those sections relating to summary trial 80, 83, 84 and 85, he shall not be liable to be tried again for the same offence by a court-martial or dealt with under any of the above sections. So this prohibits double jeopardy. Section 122 pertains to period of limitation for trial. No trial by court-martial of any person for any offence shall be commenced after the expiration of a period of 3 years. So 3 years is the cut down time, and court-martial shall not commence if the period of 3 years has elapsed. And in computing this period, it will start from the date of the offence, where it was not known that the offence has been committed. Then whenever the competent authority gets to know about the offence, the first day on which the commission of the offence is known, or where the identity of the accused was not known, the first day on which identity of the accused for that offence is known, from that the period of 3 years shall run. So 3 years is the cut-off time, and section 122 deals with period of limitation in this manner. But these provisions of 3 years will not apply for an offence of desertion, fraudulent enrollment, or for any of the offences mentioned in 37 that deal with mutiny. So naturally, where a person has run away and has not been arrested, has not been taken into custody, then he can't take advantage by saying that 3 years period has elapsed. In this computation of period, if the person concerned has been a prisoner of war, or he has been in enemy territory, or he has been evading arrest, that period shall also be excluded, naturally, because at that time he was not under the custody of his own forces. And no trial for an offence of desertion, except desertion on active service or fraudulent enrollment, shall commence if that person, who's not an officer, has subsequent to commission of the offence served in an exemplary manner for a period of not less than 3 years. That means if for 3 years a person serves in an exemplary manner, then he is not to be tried for desertion or fraudulent enrollment, because he has during subsequent period behaved himself. Next is section 123, where a person commits an offence, but after commission of the offence, he is no more subject to the Army Act. He ceases to be subject to the Army Act. The person can be taken into custody, kept in military custody, tried, punished, as if a fiction is created, he was still subject to the Army Act. However, such a trial shall not commence or must commence within a period of 3 years. Now, these provisions, you would appreciate, have been incorporated so that old ghosts are not sort of dragged into the courtroom. So if 3 years time has elapsed and a person ceased to become subject to Army Act, may have retired or had gone on discharge, or his services had been terminated, he cannot be tried, excluding period, evading arrest or absconding or concealing. If any of these three contingencies, evading arrest, absconding or concealing, is there, then that period shall be deleted from computation of 3 years period. And this also shall not apply for an offence of desertion, fraudulent enrollment, or mutiny, section 37. Next clause, which is for expediency, is that if a person is sentenced to court-martial, to life imprisonment or has been cashiered or dismissed, then he will continue to remain subject till such time the life imprisonment punishment gets over, or imprisonment is expired, or he is actually cashiered or removed, dismissed from service, he would remain subject. Aim is that if there is a war or there is any contingency, then the person is available. And lastly, when a person subject to this act is sentenced by court martial to death, the act shall apply to him till the sentence is actually carried out. Where is the place of trial? Where can court martial take place? Section 124 is relevant in this regard. It says that any person subject to this act who commits any offense against the law may be tried, punished in any place whatsoever. So it's not necessary that a court martial trial shall take place or should take place near the place of scene of incident. He can be tried anywhere. If there is a choice between criminal court and court martial, where both have jurisdiction, normal court of that place, that district, as well as court martial, if they have jurisdiction, then section 125 will decide this. It says that where a criminal court and court martial have each jurisdiction, then it shall be in the discretion of the military officer, that is, who's commanding the army, army corps, division, or independent brigade, to decide before which court of proceeding shall be instituted. And in case that officer decides that they should be instituted before a court martial, then he will direct that the person should be taken in military custody and brought to trial by court martial. So this provision, section 125, resolves the conflict of jurisdiction between a court martial and military authorities. Having seen this, question may arise as to what is the role of the convening authority. Now, the convening authority, which carries the power to convene a court martial, the three types of court martial you have seen, is to satisfy himself that the charge constitutes an offense under the Army Act and is framed in accordance with the rules. So, whatever is the accusation against him must amount to an offense within the meaning of the Act. Number two, the summary of evidence that has been recorded in that matter must disclose and justify a trial on that charge. And lastly, the case is proper one to be tried by the kind of court martial which the CO proposes to convene. And lastly, if the convening officer is not satisfied with the charge or with the evidence, he may say that he may order the release of the accused without prejudice to rearrest, or direct further recording of additional summary of evidence. So these two options are available with the convening officer where he is not satisfied with the charge or evidence. Composition of court martial. The presiding officer, as far as possible, shall be of the rank of colonel or above. That means he will not be below lieutenant colonel or below colonel's rank. And in case if it has become necessary to detail a lieutenant colonel or below as presiding officer, then one needs to take permission of the next superior authority to the convening authority. So convening authority shall go and take permission of the next superior in case a lieutenant colonel or below is to be detailed as presiding officer. Next is that if the person accused has been the CO, commanding officer of a corps, then as far as possible, as many members of court martial would be those who have held command equivalent to that of the accused, so that they can appreciate, they can understand the gravity of the offense. That is why this and such a clause has been inserted in the regulations. And the rule of sanity is that if a trial is likely to be prolonged, then keep more than the legal minimum as members, so that even if one or two get retired or get transferred, posted out, then the trial can still remain valid and proceed by having minimum number of officers as members. It is desirable to keep two or more additional members so that if accused challenges, then additional waiting members come and take the place of the member who's being challenged. nominate waiting members, and presiding officer of a DCM should, if possible, be not below field rank. Field rank is major, so an officer below the rank of major should not be detailed as presiding officer of a district court martial. Now, certain officers are disqualified to serve as members of court martial: a person who is not subject to the Army Act, one who doesn't have minimum commission service. In case an officer has convened the court, convening authority cannot be a member of court martial. Prosecutor or witness cannot be a member of court martial. Someone who has investigated charge or recorded summary of evidence must not be detailed to serve as a court martial, or even a member who was member of the court of inquiry with regard to that matter should not be detailed to serve as a member of that court martial. Also, the commanding officer of the accused can't sit as commanding officer and also as a member of court martial. The military police officers are called provost marshals. So a provost marshal at Delhi or his deputies should not be detailed. Someone who has a personal interest in that case, because most likely he may be a witness. Now, witness cannot be a judge. Witness should not be a member of court martial. Now, Army Rule 39 and 40 may be seen in this regard. These points have been summarized on this slide from Army Rule 39 and 40. If there are military exigencies or needs of discipline, say the war has broken out, then any of the rules 23, 24, 33, 34 and 95(2) of the military rules may be suspended by the convening officer by issuing an order under his hand. And if convening officer is not available, then the senior officer, he would say that having regard to the situation, this, the rules provision of Army Rule 23, 24, 34 and 95 clause 2 are hereby dispensed. So those extraordinary situations can be taken into account to make a departure from these rules. But at the same time, accused has to be given full opportunity of making his defense. No military exigencies can say that accused, you keep quiet. No, he will have full opportunity of making his defense. He shall be afforded every facility to prepare his defense, whatever is practicable, having regard to the service exigencies or necessities, and all this can be read into the provisions of Army Rule 36. This in front of you is a sample of a convening order. It says order for the assembly of a general or district court martial, order by so and so commanding this division, place, date, and it says the tale of officers as mentioned below shall assemble on this date for the purpose of this, and it lists out the name of presiding officer, members, waiting officer, members, judge, advocate, interpreter, prosecutor. And this is to be signed by either the convening authority or by his staff officer for him. Just a point to note that the presiding officer is not named. It is written that senior officer to sit as presiding officer. Name of all the members are given. There are three cases that need to be perused, borne in mind with regard to the composition of court martial. In Sodi's case, it was said that procedural defects, unless vital and substantial, do not affect the validity of a trial. Now, there may be some defects, some deficiencies, or which have been disregarded, rules which have been lost sight of, but unless they are vital and substantial, the validity of a trial is not affected. And if the accused has duly participated in the proceedings and there is no flagrant violation of any procedural provision which causes prejudice to the accused, Supreme Court will not interfere. Then in Ashok Kumar Rana, Delhi High Court said that finding and sentence would be inchoate unless confirmed. So where findings and sentence were there, but they had not been confirmed. Proceedings will be inchoate, and writ petition challenging the same is premature, and High Court will not entertain because the proceedings of court martial have not yet fructified. And lastly, Colonel Goswami's case, where convening order was issued with the approval of commanding officer who was the Lieutenant General, but there was no evidence available to prove that the Lieutenant General had given his approval in writing or even orally. It was signed by a Colonel Officer for General Officer Commanding in Chief. The Rule 37 were duly perused. They indicated that they require application of mind by the competent authority, which there was no evidence that it had been done, and therefore court-martial proceedings stood vitiated and the trial was set aside. Finally, it is to be borne in mind that authority to convene a court-martial and manner of doing so, it goes to the root of jurisdiction. These are very vital aspects, and therefore these need to be scrutinized with requisite care. Thank you.